Welcome to This Week in Education Law, School Administrator's Guide, episode number 9. This week, I focus on school liability in school shooting cases. A question I try to answer in this episode is, are schools liable for school shootings? I recently read many reports on school shootings. 2 weeks ago, Florida State Grand Jury provided the final report in the aftermath of the Marjory Stoneman Douglas High School in Parkland, Florida. Following the recommendations in that report, Florida Governor Ron DeSantis removed 4 board members from the school board of Broward County due to malfeasance, which means evil conduct or an illegal deed, the doing of that which one ought not to do, the performance of an act by an officer in his official capacity that is wholly illegal and wrongful, which he has no right to perform or which he has contracted not to do. Misfeasance, which means the performance by an officer in his official capacity of a legal act in an improper or illegal manner. Neglect of duty, which means the neglect or failure on the part of a public officer to do and perform some duty or duties laid on him as such by virtue of his office, or which is required of him by law, and incompetence, which may arise from gross ignorance of official duties or gross carelessness in the discharge of them, or from lack of judgment and discretion. Also, in the course of this grand jury, a former employee of Broward County Public Schools, who was the superintendent of the Broward Public Schools, Robert Runcie, was charged with perjury for lying to a grand jury. Some have interpreted the grand jury reports and the removal of the school board members were political motivated. Here, I focus only on school liability in school shooting cases. In addition to the Parkland school shooting report from the Florida statewide grand jury, I read interim report of Robb Elementary School shooting in Uvalde, Texas. Since Columbine school shooting, parents, survivors, and others sought monetary damages through the judicial process. For example, after Columbine school shooting, plaintiffs included students who survived the shooting, parents of murdered students, parents of wounded students, the estate of a teacher who was killed, and students who witnessed the shooting. Collectively, they brought lawsuits against the sheriff's department, Jefferson County Board of Commissioners, police officers, parents of shooters, principal, assistant principal, school resource officer, manufacturers of drug that the attacker was taking, maker of video games the attacker played, producer and distributor of video games, operator of gun shows, and gun seller. Plaintiffs asked for compensation for medical costs for those injured and other expenses such as pain and suffering. Most of litigation related to school liability, like litigation in other areas, settled out of court. For example, in March 2022, U.S. Justice Department reached a $127.5 million settlement with the Parkland school shooting victims. 2 days after the Parkland school shooting, FBI released a statement acknowledging its failure to investigate a tip it received about a month before the school shooting. In the statement, the FBI wrote, under established protocols, the information provided by the caller should have been assessed as a potential threat to life. The information then should have been forwarded to the FBI Miami field office, where appropriate investigative steps should have taken. We have determined that these protocols were not followed for the information received by the public access line on January 5th. The information was not provided to the Miami field office, and no further investigation was conducted at that time. In October 2021, the families of 17 people killed in the Parkland school shooting, most of the wounded and others traumatized, have reached a $25 million settlement with the Broward County School District in a lawsuit that had accused it of negligence. In federal courts, school liability litigation was mostly about the Due Process Clause of the 14th Amendment of the U.S. Constitution. In state courts, the litigation was mostly about schools being negligent in carrying out its duties to protect the students. In the Columbine cases and subsequent school shooting litigation, the defendants mostly prevailed. In federal courts, the defendants prevailed because of the high legal liability standards established by the federal courts under the 14th Amendment. Under the U.S. Constitution, the state has no duty to protect the life, liberty, or property of an individual when the violence is perpetrated by a private individual. The Due Process Clause of the U.S. Constitution protects individuals from the state, but not from other private individuals. Therefore, the federal government is not liable when one private individual injures another private person. This legal conclusion may be harsh for grieving families. It is why it has been difficult to establish legal liability in federal courts. In state courts, the defendants mostly prevailed because of governmental immunity, where school boards, school officers, and law enforcement officers were held not liable since they could not foresee the horrible acts. Even though a majority of cases have ruled that the school had no duty to protect a student from an intentional act of a third party, several cases have prevailed, and the school district was ruled by state courts to be negligent in school shootings. In general, when suits involving school shootings are filed in state courts, it is generally alleged that the school officials were negligent. It is elemental tort law that a negligence action requires, first, a recognized duty, second, a breach of that duty, and third, subsequent injury. In the majority of these cases, the plaintiff could not establish a duty to protect. Common tort law has historically held that there is no duty to aid another absent a special relationship unless the actor caused the peril. Most states have very narrow exceptions to the special relationship duty. Here, the special relationship duty arises when the state limited an individual's freedom through incarceration, institutionalization, or other similar restraint of personal liberty, which is the deprivation of liberty triggering the protection of the Due Process Clause, not its failure to act to protect his liberty against harms inflicted by other means. Just because states required students of a certain age to attend school doesn't necessarily mean that the compulsory attendance statute has created a special relationship duty between a public school and its students. For example, in Rod v. Pulaski County Special School District, a student named WJ brought a handgun to school and kept it in his locker. Another student informed a teacher that WJ had a gun at school. The school officials conducted 2 searches but failed to locate the weapon. On the school bus that afternoon, WJ shot and killed another student. The parent brought suit claiming that the school district had violated the Arkansas Civil Rights Act by failure to protect the student, and also that the school district was negligent, resulting in a student's death. The court reasoned that even though the school district knew WJ had a propensity for violence, this did not establish a special relationship between the victim and the school district imposing a duty to protect under the Arkansas Civil Rights Act. Another major obstacle in bringing a negligence action against school officials is that many states either have statutes that barred negligent actions against the state or common law immunity established by the state courts. In the same case of Rudd v. Pulaski County Special School District, the court reasoned that it is declared public policy of the state of Arkansas that all school districts shall be immune from tort liability and from suit for damages except to the extent that may be covered by liability insurance. No tort action shall lie against any such political subdivision because of the acts of its agents and employees. In this video, I focus on school liability in school shooting cases. Are schools liable for school shootings? Unfortunately, most of those liability lawsuits were unsuccessful in both federal and state courts. The legal standard to find an individual liable or state entities in state or federal court is very high. A monetary settlement may be able to provide some resources for those injured and address the pain and the suffering of the families, but it can never bring back a loved one. To prevent future school shootings, schools should follow safety procedures and enforce them. In the case of Uvalde school shooting, as directed by state legislation enacted in 2019, Uvalde Consolidated Independent School District adopted a policy for responding to an active shooter emergency. With respect to securing doors, the active shooter policy stated staff will conduct inspections of the classrooms to make sure doors and windows can be secured. Doors to all classrooms will remain locked during instruction, and the campuses will have one main entry point to the school. Each staff member will know the procedures to follow in order to have any door or window repaired that will not lock. However, according to the interim report by the investigating committee of the Robb Elementary shooting, multiple witnesses reported to the committee that people at Robb Elementary commonly left the doors unlocked, as people did at all the other schools as well. Teachers would use rocks to prop open exterior doors, and they use door stops, wedges, and magnets to prevent interior door locks from latching. Due to a key shortage, Robb Elementary School substitute teachers often were instructed to use the magnet system to circumvent the locks in violation of school district policy. Also, according to the interim report, when an officer was walking the floors and checking doors, the teachers would notify each other and they would lock their doors. The officers would speak to the teachers and to their supervisors, and they try to discourage the use of magnets. Common responses from teachers would include that they did not have a key, particularly in the case of substitute teachers, and that it was just temporary while a child was using the restroom. For some teachers, the inconveniences of keeping up with a key outweighed their perception of the risk of leaving doors unlocked. Other teachers were rule followers, always locking their doors. Another important task for school officials is to conduct risk and threat assessment. In the case of Parkland school shooting, Broward County Public Schools had a mandated set of procedures for violence prevention and threat assessment since 2002. According to the statewide grand jury's first report after the school shooting, at the school level, the 2016 threat assessment of the attacker was mishandled by an assistant principal who was not familiar with the threat assessment process and was incompetent in leading the threat assessment team. Moreover, Marjory Stoneman Douglas High School principal was disengaged from the threat assessment process at the school, and he failed to establish reporting procedures that would ensure he was knowledgeable about threats on campus. At the school district level, the district's threat assessment instrument was comprehensive and had the necessary components, but its implementation is flawed, at least at the Marjory Stoneman Douglas High School. School administrators lacked adequate training on and knowledge of the threat assessment process and how to conduct effective behavioral threat assessments. The school district's threat assessment process was a purely reactive, decentralized, school-based process, which is focused around behavioral threat assessment teams at each school that had little to no oversight or accountability. My topic today is a heavy one. Hopefully, the lessons we've learned from all of the past school shootings could help us prevent future tragedy.